Court, all rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Before I call the first case, I'm just going to introduce the panel to you. My name is Vuono, and to my right is Justice James Milkey, and to my left is Justice Catherine Hand. We have 5 cases that we're going to be hearing this morning. The first case we've already heard on Zoom. We may or may not take a break. We'll let you know as we go along this morning. I think everybody in this room knows that you each have 15 minutes to present your argument, that there is no rebuttal on the appeals court, and I just want to assure all of you once again, I'm sure you've heard it before, that we've read everything that you've provided to us, so we know the record pretty well, and you can get right to your points. Okay? The first case then is 2023-01, oh, excuse me, we just heard that case on Zoom. I apologize. The next case we're going to be hearing, the second case today, is 2022-0786, Commonwealth versus Michael Johnson. Good morning.
Good morning. Please the court, Joseph Giacomo on behalf of the appellant, Mr. Johnson. Getting right into it, Your Honor, Article 12 guarantees the right to a trial before an impartial jury.
I'm going to ask a favor of you. Could you talk a little bit closer into that microphone
Sure.
for us? Thank you.
I think we'd all agree with that, and part of that guarantee is the adequate voir dire to identify unqualified jurors. Chapter 234, Section 28 states that when a judge believes that there are extraneous issues, which I believe were in this case, such as racial prejudice, the judge must examine the jurors individually. Chapter 234A, 67A, the second paragraph requires an additional inquiry when it appears that decisions of the jurors may be made in whole or in part on extraneous issues. Johnson would maintain through the brief that the substantial risk of extraneous influence was recognized to be present during the voir dire.
Counsel, was the issue that the judge identified specifically a racial issue in this case?
Yes.
And what specifically was that in the transcript? Or what was it that the judge was acknowledging?
The court went through 15 jurors, 5 were sat. Juror number 23 made what the judge termed as troubling or he was troubled by the statements of the juror.
Did they relate to interracial concerns of some kind?
I would suggest to the court that the underlying premise of them raised concerns within the judge and also within defense counsel as to issues of race.
And did defense counsel then sort of disclaim those concerns and say this isn't a racial?
I'm sorry, I can't hear you.
Did defense counsel not immediately thereafter, though, disclaim that it was a racial case that implicated racial concerns?
I think what happened here, knowing Attorney Gary in his competency, it was probably, I would suggest to the court, he initially looked at it with tunnel vision, i.e. it wasn't a rape, so that it was not required. But then as soon as juror number 23 made what the judge termed as troubling statements, those blinders came off, and he did indicate to the court that he was nervous as to how the interracial assault might affect the jury pool. The judge agreed with that. And I would suggest to the court that that is the most important factor within this case. Once the judge agreed that, although it was outside of the mandated context with rape, once the judge agreed that there was a racial component to it, in that it did rear its ugly head in at least one juror, and subsequently asking the question of the following jurors to sit the panel, it was structural error for him not to go back to the 5 jurors that were already sat and ask the same question.
So if I can ask essentially, without putting words in your mouth, are you, what I understand you to be saying is there should be a rule if at some point during the course of voir dire, even in the middle of voir dire, and maybe at the end of the selection process, this issue comes to light, the judge should sua sponte, go back to the very beginning and make an inquiry of every juror.
I would suggest, Your Honor, that the rule should be stricter than that.
Okay?
We all see what is going on in society and how troubling it is. And to qualify the rule strictly for the category of rape, I think ignores the underlying intent of the rule. I do not believe that you should simply require it because of what I would say is the most heinous of crimes. Some would say murder, but a rape, the individuals, the psychological, not only the physical, but the psychological trauma could manifest forever. Any time that there is an issue of race or prejudice, no matter what, I believe that it should be mandated. If we were to have
It does have to be raised. In other words, apparently, although the parties in this case were attuned to the fact that there could be a bias against homeless people, so they were concerned about that. They were attuned to the fact that, unfortunately, that there is a bias towards people who are maybe not employed or living in the way that they were, et cetera. But there was they were not cognizant of an interracial component of this case apparently until later. I don't know what the parties looked like, but apparently it wasn't clear to anybody. My understanding of the record was it didn't seem to have jumped out at anybody, can I put it that way, until the middle of the jury selection process.
I would agree with you, but I would agree with you to an extent that it didn't jump out. But
I'm not saying that's right or wrong. I'm just
no.
saying,
It was clear that there was an interracial component. It was clear that the alleged victim was an African American and the perpetrator was Anglo. And going back to your last question, I am of the opinion that the court should err on the side of caution, and that mandated questioning pertaining to bias or interracial bias should not only be curtailed to the issue or the crime of rape, that society has not gotten to that point yet. I'm older, but I have young kids. I married late, and I always say that I am inspired about how open my children, 13 and 16, are to how people identify and what children nowadays believe. So we're going there, but we are not there. And so I think your honest question is poignant and relevant in that the appeals court should suggest that, at least in issues of interracial and perhaps religion, now that we see what's going on in the world, that it should be mandated. In this case, once it raised its head and the judge recognized that there is an issue, even though it's not mandated per se, pursuant to the underlying charge, I believe it was incumbent on him to err on the side of caution. And realistically, we're all doing trial work. I think we're all confined to moving the cases along, like we're trying to do with gun cases right now, because of the backlog. But what would it have taken to call back 5 jurors to err on the side of caution and to ask the same question?
It may have been a good idea, but no one asked for it.
And that is the problem, and that's probably why Justice Vuono is correct in that should it be mandated, because as I said, I know Attorney John Gary. He's a competent lawyer. I do trial work. In the heat of trying to remember everything, sometimes you forget something. And with a subject as important as the guarantee of trying to identify qualified jurors, if it's mandated that it has to be done, then we do not have to be in the situation that we are in today, where the judge forgot to until it reared its ugly head. Attorney Gary forgot to until it raised its ugly head. And the Commonwealth didn't suggest it until it raised its ugly head. We're all fallible. We all make mistakes. And I would suggest that's probably one of the reasons that it's mandated for rape, and it should be extended. I will rest on my brief. Thank you.
I'll just check with the
Unless there's
panel.
any questions.
No, the panel, thank you very much. Thank you for your comments. I think we can all look to the next generation.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. Your Honors, I would submit that jury questioning in this case was done very thoughtfully by everybody involved. Defense counsel and decided to err on what he described as the side of caution, and the judge, as the SJC has encouraged, gave the instruction he requested. He said it was perfect. He didn't ask for anything else. I don't think there's a basis to infer that that's because he dropped a ball rather than that he got what he thought he needed. That historically, not only inquiries on racial bias have been within, even in rape cases, even in interracial murder cases, it's only if defense counsel requests it. It's not, it's a strategic decision. It's a strategic decision you may frequently choose to take. But
Once the judge decided that he should ask the question going forward, putting aside whether it was mandated to ask the earlier jurors, wouldn't that have been a good idea?
Well, I think it's instructive in the previous day, there was a motion in limine session, there was a discussion about a different issue, about how a police officer knew the defendant was able to recognize his voice, and the judge said, you know, if you want, I can give a limiting instruction, and defense counsel said, you know, Your Honor, I'm finding those limiting instructions sometimes draw more attention, and the judge said, I think with any case, I can let you two try the case, and if you think that a limiting instruction is helpful, I certainly would consider doing it, but if the parties don't think it's helpful, you know, I don't intend to kind of stick my nose in it. So it's conceivable that defense counsel would want this question asked as part of a whole lot of questions, but he wouldn't want to bring back the 5 seated jurors and ask them this one question because it might give them the idea that there was a racial angle or a romantic angle to the extent that they were trying, which he clearly did not want, that he might have thought, I mean, he also gave thoughtful comments at the previous day about why he wanted individual voir dire so that he can get a better flavor of the jurors, and he'd just seen those 5 selected, and he may very well have concluded that he liked them, he didn't think he needed to hear anything else from them, and that bringing them back for this purpose could give them a suggestion that they didn't have. And I think it's...
The judge theoretically could have asked defense counsel.
Yeah. I mean, he could have, but I think that again, this was certainly you could. I think that this was a context where defense counsel, by his own admission, was not proffering a substantial risk of extraneous influence. He was just saying, you know, maybe we should just to be safe. He wasn't suggesting that he thought it was necessarily mandated by the case. The judge just said, you know, what do you want, and gave it to him. He didn't say, I find that there is one. Again, I think that while certainly there's, I mean, appellate decisions over the years have differed, I think, a little bit in terms of whether the justice writing them thinks that there's no harm on erring on the side of caution and asking everything, or whether there's some more strategic nuance. I mean, 40 years ago, or possibly earlier, at one point the SJC had the rule that you have to do an individual voir dire of the defendant before you make a racial bias inquiry of the jury, because it was considered to be really dangerous, and then they decided that wasn't how things usually worked. And recently, obviously, there's been trending both in favor of asking more about it and also more neutral ways of phrasing the decision. I mean,
Because you're saying sometimes the courts are able to read the Times, huh, and move forward? Is that your?
Sorry?
Just
Oh,
saying.
yes. I'm sorry. I forgot to put my hearing aids in this morning
Oh,
of all
that's-
times. So, I mean, I think that, that this was I think the earlier cases were contemplating are you racially biased against this group, which they worried would be, I mean, whereas here it's just, here's the situation, is there anything about it? And I think, I mean, obviously you can't guess because it didn't happen. Ineffective assistance wasn't raised. We don't know what his strategic decision was. But if they'd gotten any answers from the jury that suggested that anyone did have a problem with it, quite likely everybody involved, given the tenor of the discussion on all of these jurors, would have, I mean, the fact that the judge went out of his way on the record to say on juror 23, here's a thing I find frustrating about, that people have horrible experiences with law enforcement that then lead them, but he's like, I really want, this person would bring a valuable experience to the jury, but reading him, I think he'd try to be impartial, but essentially I think that he couldn't be. He was clearly putting so much thought into this above and beyond, and made sure that the juror understood that, he brought a valuable perspective even just by being there. They were all thinking really hard about this, about everything. And so I think that if they got any, and there were some observations about, we're getting a lot of police officer answers. Like, they all noticed that. There were a lot of jurors who had thoughts about that. They were not reluctant to say in one way or another. Sometimes the jurors didn't actually say which direction. Some jurors had stories, but that if they'd gotten any answers at all to the question on race, it may have led them to think there was something they had to look into, but where that did not appear, certainly on paper, it didn't register with the jury, and inferentially, it didn't register demeanor-wise with the jury. It's a very technical point, but actually one of the first 5 jurors was the alternate, so technically it was 4 jurors. That wouldn't make any difference, but just as a matter of numbers, who sat on the ultimate jury who were not asked about that. But I think that everybody, again, I think it is laudable that defense counsel wanted to cover every base, even though he did not think that it was really implicated by this case. It's laudable that the judge gave him what he wanted. They came up with a perfectly reasonable question. It did not appear to get any answers, whatever, and I think that all of that is, to their favors, and, yeah, I think that it was very well handled.
Okay.
And
Question? No further questions. Thank you both very much for your
Commonwealth
argument.
Thank you.
Our next case is case number 2022-1096, Commonwealth versus Ralph Sanchez. Good morning.
Good morning, Your Honor. May it please the Court, John Matus for Ralph Sanchez. Your Honors, it's called the first complaint witness, not the best complaint witness or the most convenient complaint witness for the Commonwealth. And in order to get a substitute first complaint witness, there has to be some form of reasonable efforts. Here, the fruits of the Commonwealth search were rotten because the search itself was rotten, not reasonable. We have a situation where the actual first complaint witness is discovered in the courthouse while the jury is still deliberating. The Commonwealth didn't even check in custody or its own docket.
Can you explain something to me before we get on? And that is, the judge in this case invited a post-trial request to look into what actually happened in this case. What happened there?
There was the judge said you may want to file for a motion for new trial. But given the circumstances of this case, and I'm CPCS appointed, the course of action I made the strategic decision to do an appeal rather than a motion for new trial. And if
I'm not going to I have no opinion one way or the other about anyone's strategic decisions. That's not my point. But would you agree with me, though, that as a result of that decision, there's some information that might be helpful to know to determine whether or not the Commonwealth actually met its burden of reasonable diligence with respect to locating the true first complaint witness, which everybody knew was the first complaint witness. There was nobody was hidden. It wasn't buried in any way, shape, or form.
I would disagree, Your Honor. I think the evidence that is in the record is sufficient. I don't think we needed a motion for new trial to discover it. And second, there was one party that didn't agree he was the first complaint witness, and that was the Commonwealth, but that was merely because the Commonwealth did not make any reasonable efforts.
Yes, I see what you mean. In other words, in the beginning of the case, the Commonwealth was promoting the sergeant first, and not later. But that got would you be fair to say that got cleared up fairly soon?
That did after the trial had begun and voir dire occurred. So the trial was already underway because the voir dire occurred after the jury empanelment.
Could I ask a question? I'm sorry, if you finished answering Justice Vuono's question?
Yes, Your Honor.
Could I ask one more so I don't interrupt your flow later? Can you help me with the issue about the first complaint, the actual first complaint witnesses, Mr. Oliva's presence? That was secured based on his having waived extradition from Virginia, is that correct?
No, we do not know how his appearance was secured. All that we know is the Commonwealth had never bothered to secure him at all. They had never bothered to procure him or even find out where he was. What occurred was—
This is my question, is I just want to ensure that I'm understanding correctly that the process that brought Mr. Oliva into court was not recorded in some way on the docket as far as this case goes, and it was not part of the, at least from your client's point of view, an effort to bring that individual in for the purpose of testifying here. It was for another purpose.
That is correct. What occurred was defense counsel was asked to represent someone in another courtroom while the jury deliberations was going on. He went down and discovered it was Mr. Oliva by happenstance. It was a completely different case. He just happened to notice that this was the exact same person who was the first complaint witness.
With a different name, different first name.
It was claimed that in the record, which again, that it was, I believe it was Jose, not Luis, and the alleged victim had said his name was Elise Oliva, and then the Commonwealth said, well, this was listed as a different first name. But whether that was actually true or not, we did not know because the court did not have Mr. Oliva come in and be heard in a hearing, nothing was put forward. In fact, that's one of our objections here, is that without even allowing the defense counsel to discuss the matter with his client or raise an objection or formulate an argument, the court merely shut him down and said, I'm not going to declare a mistrial. I'm just going to go forward. I'm not going to let you talk to your client. And this was at sidebar. This is recorded on the transcript of the third day. And to me, that was quite shocking to not even allow the defense counsel to just discuss it with his client. Perhaps his client might not have wanted to go forward with it, but at the very fact that the Commonwealth had been crying that it could not find Mr. Oliva, and then he was in the same courthouse, raised quite a few questions, obviously.
Yeah, but don't we need a hearing to answer those questions? The Commonwealth claims a good faith basis for thinking that Mr. Oliva was not available. And you question that. And the judge offered an evidentiary hearing to get to the bottom of that, and you said no. I'm not saying that was the wrong choice, but I'm having problems seeing how we can resolve whether the Commonwealth acted in good faith without the factual record necessary to determine that.
I think that the morning hearing, the pre-trial hearing, that was before a different judge, and I don't believe it was Judge Meshera. I'm sorry. I know I listed that in my brief. I just want to correct that. It might have been Judge Meshera, but it's unclear. But no, the evidence is the Commonwealth stated it had a few conversations with the alleged victim, and then it had the last meeting it had was in August. It still could not determine who the first complaint witness is, and it stated that it hadn't done anything to secure this witness. It had made a phone call.
Can I say, I thought the prosecutor represented to the judge that they had, in fact, looked for voluntary extradition.
The Commonwealth had stated that, but it did not state that it had located him at all. It had stated that it had looked into getting a voluntary extradition without knowing where this person was. And
I read it as there was a request for voluntary extradition. They were going to seek a governor's warrant, but there's no more information about that, so we don't know if one was ever sought, right?
yes.
But this was, of course, represented to the judge at the very end after Mr. Oliva was discovered, so to speak. And then to Justice Hand's point, though, however, we don't even know why he was there, in the sense that the prosecutor seems to think that maybe he decided to acquiesce to extradition. Maybe it was a different case that he was being extradited on. We don't really, do we know anything about that? That we only have those couple lines from the prosecutor
We have
to
another
the
line,
judge.
sorry, excuse
Oh,
me.
go ahead, yeah.
We have another line from the alleged victim. This is on the second, during the voir dire, which is on the second transcript, page 105.
Yeah.
She states that she doesn't actually know where he is. He could be in Massachusetts or in Virginia. The Commonwealth is merely stating, oh, I think he's in Virginia, but we never bothered to establish that he was the first complaint witness. We've never done anything. I've called his number, there's been no answer, that's it. And I would contrast that with the efforts in a case such as, I think, Morongo, where they hire an investigator. The investigator actually makes contact with the first complaint witness, and then the first complaint witness, Alice, excuse me, drops off the face of the earth. Those were reasonable efforts because the investigator had followed up repeatedly. Here's a situation where Commonwealth never followed up. In fact, it didn't even know where he was or where he might have been. It's merely making a guesswork, and we know that it didn't even talk to the alleged victim even on the day of trial, because the alleged victim got up and directly contradicted their own motion, because they said, well, Sergeant Internicola, and the alleged victim got up there and said, no, I told about the sexual assault to my cousin first. So the Commonwealth's motion was just untrue, and it would not have been untrue had they even talked to her.
I'm having some issues with your saying things like that. It was untrue. We're not really sure it's untrue. If we heard from the prosecutor, it could very well have been that the victim said something different at one time and something different another, possibly. In other words, without more information, to Justice Milkey's point, can we make those allegations towards the prosecution in this case?
Yes, Your Honor. I believe we can, because if the only source of the information is the alleged victim, and it's, as I believe it was the first hearing judge, he says that the problems that the prosecution has in securing a first complaint witness are not the problems of the defendant or the court. If they cannot secure it, they don't get a first complaint witness, or they have to show at least reasonable efforts.
Correct.
So it's up to them to demonstrate the reasonable efforts to get the substitute first complaint witness. So to state, the Commonwealth's statements arguing for a substitute first complaint witness was, we've had trouble talking to the alleged victim. The last time I talked to her was in August, the last time we had a meeting, and I believe that's stated to be the first meeting, but there might have been phone calls. We've got a phone number. I called it once. There was no answer. That's all I've done. I hired an investigator, Your Honor. They've been on the case. They've been talking to
Not to repeat myself, but later the prosecutor says that they did try to engage or put steps in place for a voluntary extradition.
They did state that, but she did not state what state he was in, how they discovered.
I understand that there was not much information there, but
and when the Commonwealth, since the burden here is on the Commonwealth to put forth the reasonable efforts, therefore the burden, and if they didn't present the evidence at all these hearings, especially when they're moving for the continuance, basically stating we haven't made reasonable efforts, then...
Let me ask you this then. What if there was a hearing and it was shown that, yes, indeed, the Commonwealth had done exactly what they indicated they had done, that they found out that the person was in Virginia, that they then sent a request for voluntary extradition, that it was refused. They then sought a governor's warrant that wasn't obtained. And of course, they're not always so easy to get because, as you probably well know, and they could have explained the reasons why that was refused. Would that have been reasonable efforts as far as you're concerned?
If they had stated that when they were moving for the continuance, that might have been sufficient. Depends on a number of factors, how detailed they went into. But in this case, when they moved for the continuance, they moved on the basis that they hadn't been able to discover him, and they'd made reasonable efforts. So it's their job to purport it. So anything that's not in the record, we cannot, a future hearing would only be giving them a second bite at the apple that they do not deserve. All they had to show is what they did.
How's that? All they could do is present what actually happened. They can't make things up at a second hearing.
Exactly, but at this point, they were required pre-trial, or at least, I'm sorry, before getting the substitute first complaint witness, to present enough evidence, that we reasonably went after this case. So all the evidence in the record is all they get to rely on. They don't get, oh, okay, we screwed up, now we get another chance at it. The first complaint witness is not, it's not a matter of right to the Commonwealth, or a substitute first complaint. It's not a matter of right. It's a matter of the judge's discretion. And so for the Commonwealth to argue, well, we'll show more evidence of reasonable efforts in a hearing, if you just give us another chance at it.
Now I'm understanding your strategy a little bit more. I think your point is that the Commonwealth had the opportunity then to show that reasonable efforts were made, and that's their shot.
Yes.
And they don't have the opportunity to do it later, even if it's not, if I might add this, sufficiently raised or objected to. That's the time when they have to show their reasonable efforts, and not later on.
Yes, Your Honor,
Okay.
that is our stance.
Before the clock expires, could we talk about the issue of prejudice?
Yes.
Because whoever the first complaint witness was, he or she was the only a first complaint witness and not a merits witness. Why did it matter all that much who the first complaint witness was?
As I raised in my reply brief, and once again, in my reply brief, I do apologize to the Commonwealth and the court for misstating this standard. But as I raised in my reply brief, there are two issues with the substitute first complaint witness. The first issue is, of course, that the problem that Asenjo raises, and I do point to Commonwealth v. Asenjo, A-S-E-N-J-O. I've cited in both my briefs. I believe that's the most applicable case here. The first is, Asenjo directly warns that a police officer's status, especially in a case where the only direct evidence is the claims by the alleged victim, a police officer's status as the first complaint witness can unfairly tip the scales of credibility in favor of the alleged victim. That's Asenjo, and that's even with proper jury instructions that are not challenged. We assume that the jury will listen to the court and state, we're not going to, to the limiting instructions for the first complaint. Even then, in Asenjo, where there's no question about the jury instructions being improper, the court says a police officer's status as a substitute first complaint witness is a very, that can tip the scales here. The second, and I also raised this in my reply brief, is the fact, and this is also raised in Asenjo, and I believe also in Alice, is that when a substitute first complaint witness can give more details than the actual first complaint witness, that's actually a danger as well because of the credibility issues. And here, the alleged victim states at pages 104 to 105 of the second transcript, the voir dire, the first day of trial, she states, I gave more details to the police officer than I did to my cousin, Mr. Oliva, including a detail about the ripped pants, which the police officer testifies to. And that is a danger that Asenjo also says is also a danger because this, if you give more details, and the substitute first complaint witness is therefore corroborating more of the story, then that can unfairly tip the scales of credibility. And especially in a case, like I said, where there's no other direct evidence besides the alleged victim's testimony. They have wildly divergent stories, but the only evidence is there. And of course, not even physical evidence, because as the police officer states, he didn't have the smarts, that was his words, not mine, to bag the pants as evidence. So they were never presented as evidence. So we never saw any direct evidence. And so that is the dual prong of prejudice. Police officer status and the fact that in this case, just like in Asenjo, more details from the substitute first complaint witness than the actual first complaint witness.
Thank you very much. Your time is up, and there are no more questions. So
Thank you, Your Honor.
We appreciate your argument.
Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth. Your Honors, the question here is really, it boils down to, did Judge Chapman abuse his discretion when he determined the first complaint witness who was identified during the voir dire was unavailable? So that's what we're actually looking at here. And I'd point you to the written margin endorsement that he made that you can find at Record Appendix 89. He concluded, and I'm quoting, unavailable, period. He lives out of state and is currently in custody. So those are the determinations that Judge Chapman made in September of 2018 with the benefit of both King and Thibault, both cases that he cited, that were the controlling law that existed at the time. There's nothing in there where he abused his discretion. So defense counsel seems to want to rely a lot on Asenio, so let's start right there with how different this case actually is from Asenio. In Asenio, it was the fourth complaint witness who was used, and it was a police officer. And those 4 complaints happened over a period of 2 years. So we're already categorically different than here, where the incident happened, she spoke to her cousin on the phone on FaceTime immediately afterwards in her car, got off the phone with him, drove directly to the police station.
Spoke with somebody else and then went to the police station.
While she was driving, a second cousin of hers called her, but that didn't slow her down or stop her on her trip directly to the police station to report. This case is much closer to both Alce and Thibault, where they said what could be complaints to different people that are so close in time are essentially one contemporaneous report. This case is much closer to that than it is to Asenio, where we're talking about over 4 years, and it's the 4th person she told. And in one of those reports,
I think that we can agree that Arsenio has facts that are distinguishable. But I'd like to go back to the judge's ruling that you've pointed out in the appendix here. And it doesn't really explain what the Commonwealth's efforts were to obtain the first complaint witness, does it?
That's true, Your Honor, it doesn't, but I would also point you directly to the quote from the victim herself during the voir dire, which is really the only information that exists here. First, when she was describing the incident, she said she spoke to Louis Oliva, and he was in Florida at the time. So at the time of the incident, he was out of state. Then and that was at volume 2, page 101. The only other remark that she made was volume 2 at 105 to 106. I believe he's in custody. Not sure if he's in Massachusetts, or last time I heard he was in, like, Virginia. So that's the information that the judge had. So
But the question is that what did the prosecutor do with that information initially? Because the prosecutor walked into court wanting to go with a police officer, not really establishing the fact that there was somebody else. And, you know, was there an inquiry of another relative? Where out of state? Was there an inquiry in terms of just throwing the name and social security number and date of birth in the system to determine whether or not he's incarcerated in Massachusetts? I don't see where any of that was done prior to trial or represented to the judge that was done as part of the reasonable efforts.
Your Honor, I agree with you.
Yeah.
The prosecutor didn't put anything on the record, but there wasn't a motion for a new trial here. It wasn't raised at the time.
But at that time, to the point that your brother was discussing earlier, is you're absolutely right. There's not a motion for a new trial, and we'll address whether or not that should have happened ultimately. But also, at day one, the prosecutor has a certain responsibility here. And does it require, well, your answer is going to be no, but do the cases say that it requires a little bit more than what happened here?
The case that happened 2 years after this trial, Alce, is the one that defined what reasonable efforts were. So let's look at Alce. The defendant derives the benefit of changes in the law while his direct appeal is pending, even though he took 4 years to make it happen here, allowing for this change in the law to happen.
Well, we can, okay, he gets it.
But if you look inherently at what the statement was from the victim, that's where we find our facts that are relevant. What is that quote again? I believe he's in custody, not sure if he is in, like, Massachusetts, or last time he was, like, in Virginia. So what is that? He's estranged. He's estranged. The family doesn't know where he is. That's the same as Alce.
Well,
He's estranged.
How do we really know that?
That's a cousin, and
Okay.
she doesn't even know where the cousin is, or isn't sure what state he's in, isn't even sure if he's in custody or not.
She doesn't know, but how do we know that he's estranged from the family, as you just said?
All that we have are the facts that are in the record. So we have that one statement right there, and it's a reasonable inference from that the cousin doesn't even know what state he's in, or if he's in custody or not. That's a reasonable inference that he's estranged from the
It's a
family.
reasonable inference that the victim doesn't know, correct? All right.
Correct. So I would point you right to Alce. What are the 4 things that they relied on in Alce? A minor, out of state, estranged from the family, and not answering the phone number that the ADA had. So let's compare our facts to those facts. We don't know the age of the cousin, so we don't know about minor. Out of state, the only information that Judge Chapman had was out of state. Estranged from the family, the only information that Judge Chapman had was estranged from the family. So the only difference between this
I guess I can't make that leap. I don't understand how you're making that leap, that there's estrangement from the family because this particular person doesn't know where the cousin is.
Estranged from the one person of the family that this ADA would have a reason to talk to, which is the victim. The victim doesn't know where this person is.
Okay, so estranged from her, but you said from the family, so let's just keep it
All right, estranged from her, as opposed
Okay.
to the entire family.
All right.
And then in Alice, he wasn't answering the phone number that the ADA had.
I think Justice Milkey has a question.
Could you address one fact that causes me some concern? If I'm remembering the record correctly, the prosecutor announced in the opening statement that the jury would hear from the police officer that she reported the crime to. This was before the first complaint witness was approved by the judge and before the voir dire. That strikes me at a minimum as bad form. Could you?
Well, Your Honor, it turns out she was right. So a prosecutor runs a risk anytime they promise a jury anything at all. But it turns out that that happened here, so there's no problem. And again, that's not an issue that was raised by the defendant in appeal, so that's not really something that we're here to talk about today. So back to Judge Chapman's ruling, lives out of state and is currently in custody. So that's the question here. And how does that compare to the Alice case? And respectfully, that's the same situation here. So the only difference that we've established is the lack of a phone number, that in Alice, the ADA had an investigator in the office call the phone number that they had for the first complaint witness. And here we don't have information.
Right there is another big difference, because in Nal's case, we actually knew that there was an investigator who actually made a call, and we don't have any information that the prosecutor or an investigator or a police officer did that here.
And an investigator who made a call that then wasn't answered. So I'm not sure how that fact is really all that valuable.
Well, I guess what I'm getting at, and we've already talked about this, and so we can let it go, is that the prosecutor is required to make reasonable efforts, and here we have statements made by the victim as to what she knew about the first complaint witness, but no real evidence as to what the prosecutor did thereafter with that information. That's what is the point.
Your Honor, you're correct, that's true. However, I'd say two things in response. One, based on the statement from the victim, there really weren't any reasonable efforts on the part of the prosecutor that were going to result in the person appearing here in state.
Could be.
If the person is in custody somewhere out of the state, maybe in Virginia, a governor's warrant isn't even going to get, if they knew for sure that this person, who, by the way, she was using the incorrect name for, apparently, we don't know because there was no motion for a new trial, if she had been using the correct name, if they'd identified the person somewhere, how do they get the person here? A governor's warrant doesn't transport a witness.
I'm going to move you forward a little bit to what must have been a surprise, of course, pretty evident to everybody, that the person ended up being in the courthouse on the day that the jury was deliberating. What obligation do you think there was on the prosecutor then, at that time, to make some investigation as to how it was that the person that they knew was the first complaint witness was in a courtroom in the Commonwealth?
Your Honor, I'm not sure under what there would be an obligation for the prosecutor to conduct a further investigation then.
So as far as you're concerned, it was over with at that point in time?
Judge Chapman had made a decision that the witness was unavailable, a substitute was called, the substitute testified, the jury was deliberating. Let's assume that this additional information that came out is true, which we don't even know, but let's assume that it's true, that the person that would have been the correct first complaint witness was actually in the courthouse. Then it was on the defense to do something about it. Judge Chapman can't unring the bell, it had already happened. So he specifically asked the defense counsel, what are you asking me to do? Defense counsel said nothing, nothing right now. He could have asked to bring that person from the lockup up, put him under oath, do a voir dire, at least confirm if it is in fact the correct person. Could have at least done that. They didn't do anything. They just decided to lay in wait and see what they would get from the jury and then see if they could use this to their advantage down the road. And then counsel made a strategic decision to not pursue a motion for new trial, so there's no record, so that all we have is this mess, basically. But it ultimately goes back to, and so the only thing that Judge Chapman could have done then was sua sponte declare a mistrial, which is well within his discretion to not do, and frankly would have been a terrible choice, because then we would be arguing about the ability to retry them. Was there a manifest necessity for a mistrial to issue? And if there wasn't, then we wouldn't have been able to retry the defendant at all. So Judge Chapman didn't abuse his discretion and not sua sponte declaring a mistrial.
Was there an abuse of discretion in failing to allow counsel to pursue that question with his client?
Your Honor, I disagree with that characterization of the record completely. The defense counsel brought something to the judge's attention while the jury was deliberating. There's nothing that would have stopped the defense counsel from going to talk to his client in lockup. He absolutely could have done that. To characterize it as the judge somehow prevented that from occurring is simply not true. He goes and talks to his client in lockup. They get word the jury's come back with the verdict. He comes back and says, Judge, sidebar, we're asking for a mistrial before we get this verdict. He didn't do any of those things. So Judge Chapman didn't abuse his discretion when he determined that the witness was unavailable based on the information that he had. And then he didn't abuse his discretion when this information that we're not sure what it was brought to his attention while the jury was deliberating. What he did do was ask the defense attorney, is there something you want me to do? The defense attorney said no. He said, okay, I'm going to let the jury come back. You may have grounds for a motion for a new trial, and informed him that motion for a new trial would come back to me because I'm the trial judge. Volume 3 at 179 to 180. 100% correct. The defense decided to do nothing with that information. Here, Judge Chapman did not abuse his discretion in any way, either in his initial determination or in not sua sponte declaring a mistrial. This case is much closer to Allison Thiebel than it is to Asenio. We didn't talk about Thiebel at all, Your Honor. I'd like to piggyback on my position that Alice is close with Thiebel. In Thiebel, it was the same sort of situation where the court determined, one, the first complaint, actually the father, the actual first complaint witness is not available. He's out of state. He's voluntarily gone out of state. We're going to allow mom to be the substitute. And they noted that it was essentially a contemporaneous report there, and that the victim told dad, dad took the victim to mom, and then she repeated and provided all of the detail in front of mom and dad. And because it was essentially a contemporaneous report, not as much of a problem. That concept was embraced in Alice the same way. And in Alice, this court noted when these arguably series of reports occurred during one family trip to Florida, so a family vacation, the victim reports it to the first family member, that family member tells the second family member, tells mom, mom confronts victim, victim tells everything to mom. All of that happened over a multi-day family vacation in Florida. They used the same reasoning, this court used the same reasoning back in Thiebel and said essentially one contemporaneous report. Same thing applies here. She's on the phone outside of a residence right where it occurred, talking to her cousin. She gets off the phone with him, being safe, drives directly to the Revere police station, makes the full report to the police officer. It's essentially the same factual situation. One contemporaneous, continuous report, as was seen in Alice, as was seen in Thiebel. Judge Chapman didn't abuse his discretion in allowing a substitute first complaint witness here. If there are no further questions.
I see none. Thank you very much. Thank you both very much for your arguments. We'll take the case under advisement.
If I could just add, I thought both sides argued very well in this case.
All right. Our next case on the list is 2022-1134, Commonwealth versus Victor Vasquez.
Good morning, Honors. May it please the Court, Alex Conley for Mr. Victor Vasquez. Your Honors, I'd like to start my argument here talking about the second issue I raised in my brief, the motion to suppress. This issue involved the staleness of the search warrant, which I think both parties are on the same impression as far as this is basically an application of the Gastauchi case, which discusses whether or not this search warrant was stale. I don't think there's been much analysis of the Gastauchi case subsequent to this, so I think this is an opportunity to kind of clarify and look at the borders of that Gastauchi case's decision in Massachusetts. So I suggest that this case, the differences between this case and Gastauchi are where the line should be drawn as far as whether something can be stale. First is the time limit, which Gastauchi had a 7-month time limit and notes that's basically the outer limit of what they expect a reasonable time could be. Here we have a longer time, albeit just 1 month.
Only slightly long.
Only slightly, but albeit that was the border, how far does that border push? Gastauchi is clear that there can't be a de facto presumption. There has to be some temporal limit. In this case is an opportunity to say 7's the outer limit, 8's the outer limit. Next case will be 9. We'll just keep on pushing and pushing and pushing until we're years down the road. I think that this 8-month time period could be relevant for that purpose. But the other, and I think more important aspect here, even than that, is whether or not this affidavit showed sufficient evidence of an interest in child pornography. So I would actually look at the way the Commonwealth brief does a good job of explaining the kind of 3 ways this affidavit indicated that this cyber tip could have been developed here. It was either the cyber tip was based on uploading of a picture to a reverse image search, or entering a URL that linked to an image, or quoting from the affidavit itself says, clicked on the share button on an image of child porn using Bing. Any of those 3 ways could have developed this this cyber tip. Any of those 3 ways, I suggest, is not sufficient under Gaustauchi to show that this is a person interested in child pornography. It requires a significant number of steps, of complicated steps to show that interest, and this one, I just don't see that here. If somebody just clicked an image and clicked the share button inadvertently once, that would be enough to suddenly show they're an interest in child pornography. They have an interest in child porn 8 months later.
Here, from the affidavit, don't we know that the image was entered into the reverse image search on Bing? And if that's true, why isn't that enough? Where we don't have the image, but there's a description of it in the record. And we're not talking about something on the periphery of child pornography. If someone is in possession of that photo and then uploads it into the reverse search image, which was presumably done to find similar photos or photos of the same person, why isn't that enough to demonstrate an interest in child pornography and not just a passing click?
So at the first point, Your Honor, looking at the language in the affidavit itself, I don't know that it specifically says this is the officer's opinion is what likely happened as opposed to what the cyber tip actually told him. The cyber tip only told him it could have been one of those 3, and he found the link to the image by going back through by doing the warrant for the provider. That image could have been either uploaded, clicked the share button on that image, or that image could have been what was linked to by a URL being entered into into Bing search. So that's the first point there. The second point is
Let me just interrupt. So in other words, you're saying because there's 3 possibilities and the search warrant affidavit didn't establish which of those 3, and let's just say for argument's sake, 2 are just clicks and easy and one's very complicated, that would be, in your view, a reason to say that the search warrant was insufficient to show interest in child pornography.
I think it would be, and if you look at the language of Gaustauchi and Raimonda, to which it cites, it talks about it. The point of this is to show.
Right, but this is a 3rd possibility here. So, had the search warrant just said 1 and 2, the two quick clicks, for example, you would have a more compelling argument, obviously. But the search warrant doesn't have to. It only has to establish probable cause. That's one of those 3.
Yes, I understand your point. I think that. Well, first off, I think that in this circumstance, any of those 3 by themselves, even once.
So each one, as far as you're concerned, none of them are sufficient. Even not just 2 are not and 1 is. None of them are.
I'd suggest that none of them are sufficient in and of themselves especially because this is a one-time event, 8 months in the past, not a series of things. We look at.
Okay, understanding that that's what you're arguing. What if, say, 2 are sufficient and 1 isn't? What are we supposed to do with that?
If 2 of the methods could be sufficient and 1 was not, I think that would cast doubt on the probable cause determination. It would cast doubt upon the probable cause determination. I don't think it would be, and as all these cases note, they're very case-by-case specific. Every case should be looked at the facts. The description of the image itself might be relevant. The description of the exact method Bing uses might be relevant. All of that could be relevant. I think certainly the more that's in that affidavit could bolster the probable cause. And in this particular case, I don't think there's enough there. I don't think even a reverse image search for a single image of child pornography as described would necessarily show that this person is somebody who has the predilection for child pornography in all instances.
Help me out on that, because the person has the image. So they know what the image is. We have no idea how they got the image, but there's the image, and then they put it in the reverse search engine to find other images like it. Why isn't that sufficient to show an interest in child pornography?
I think in that instance, the issue is whether or not there's other aspects of the image. Because this is a one-off as opposed to a number of instances, that there could be other reasons that image is being searched. And to show a sufficient interest based on a single image alone I think is a very difficult thing to show. I understand the courts have said one instance can be enough. In Gaustauchi, they actually had to show that the image was shared, not just looked at, but they show it was shared via
It doesn't
Skype.
say it has to be shared.
It doesn't say it has to be
If it's shared, that's
significant, I think. That I would describe that case as saying this: the sharing in Gaustauchi is a significant factor they'd consider. That it's not just looked at, it's not just viewed, it's actually shared.
is a significant factor in that case.
Correct. I'd suggest that that is a significant factor that is absent in this case. I'd also note that the other factor, that's a series of sufficiently complicated steps, is not really met with any of these as well. I'd suggest there's some things they talk about turning off the safe search in the affidavit. That doesn't really show anything as far as the child nature of the pornography being searched for. So I don't think there's necessarily a series of steps in any of these, perhaps one step in any of these possible ways. Moving on to the other issue, Your Honors, as far as the admissible evidence, we basically have hundreds upon hundreds of searches, hundreds upon hundreds of browser history admitted to trial of various child pornography and regular pornography, as well as just the computer's entire browser history that was on the ADF report. I think all of this is inadmissible character evidence. It's used for a propensity purpose. I don't think this is a case where the probative value outweighs the risk of unfair prejudice. I don't think this is a case where, and I think this is an important factor here, is the defendant wasn't arguing accident here. He wasn't arguing he accidentally downloaded this image not knowing what it was.
He was arguing that it could have been somebody else.
Correct. So this is where this case is just like Creighton, and that's something that was the point was Creighton was identification: who downloaded the images, who viewed the images. So the first.
But doesn't at least some of this evidence go directly to that point, though? If he is looking at these sites at 2:30 in the morning, it's pretty strong evidence that it likely wasn't somebody else who was.
I think there's two issues with that being to be so black and white there. I think first is the time frame here, is that these searches and browser history that was brought in as the separate exhibits comes from months before this happened. So I think that's not showing, like in Creighton, what I call Creighton 2 in my brief, which is the third Creighton case, I guess, the unpublished one, where they found it was admissible because it was right around the same time.
We don't know when the 10 images that were put before the jury were found, do we?
I believe that is in the record, Your Honor.
I mean, we know when they were found, but when they were downloaded?
I believe that's also in the record. I believe that they were downloaded in April of 2019 is when those images were downloaded. And I can look through the record. I don't necessarily waste my time looking through the record right now for that, but I believe I had that written down as a note at least in April 2019, which was the search history was July through November of 2018. So these are many months prior to. So that's where it's different from what the court said in Creighton 2 about that kind of exact argument being a valid reason this can come in. And then the issue that also arises then is not even that, even if there was some relevance there, like for the reasons Your Honor discussed, the pure amount of it was not relevant. They ended up multitude of.
Let's say that issue had been raised at trial. And let's say the judge might have said, okay, Commonwealth, you're going overboard. We're going to give you 5 or 10. Choose a number, examples, but we're not going to let you put in hundreds of these searches. What difference do you think that made and toward proving a substantial risk of a miscarriage of justice, where the pornography was found on a computer to which, from all indications, he was the only one who had access. And in an interview with the police, he admitted that he searched for child pornography, stored child pornography, that child pornography would likely be found on his computer, and that he was sexually aroused by children.
I think the substantial risk of a miscarriage of justice arises essentially for two reasons there. I think the first reason is that without the jury instruction to explain any of this evidence or even give the jury some understanding of why this was admitted, I understand it wasn't requested and the judge hasn't necessarily required to give such an instruction, left the jury in a place where they could have very much been convicting somebody based on this entire landscape of evidence. Knowing this person had been searching for would create an inference that he must have had it at some point, whether or not they believed that these particular images on this particular occasion in April were downloaded by Mr. Vasquez, and that was part of the defense's argument at trial. There was reasonable doubt as to who downloaded these specific images, not just reasonable doubt in general, but as to these specific images. The Commonwealth could not meet their burden to show these specific images. And where the jury was left with an unqualified, unexplained plethora of child pornography evidence, which I also note is the second factor there, was this evidence took up significantly longer portion of the trial than the evidence of the actual images downloaded. Multiple exhibits, multiple questions about these without the same for the actual exhibits. The jury could have convicted for that and not the actual possession, which was the downloaded, saved images. If there are any further questions, I'd be happy to answer them. Otherwise, I will rest on the remainder.
No, thank you very much. I see no further questions.
Thank you.
Thank you for your argument. Okay, Commonwealth?
Good morning, Your Honor. Aaron Stoudinger, and I may please the court. Aaron Stoudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. I just for the sake of clarification, I'll begin with the first argument because the dates, and I'll beg the court's apologies, I did not put record citations next to my notes here. But it was in the second transcript. The images were saved to the computer on April 18th of 2019, June 2nd of 2019, and October 13th of 2019. The browsing history covered November of 2018, November 29th of 2018, October 16th of 2019, and October 20th of 2019, and the search history covered July of 2018 and November of 2018. All of that to say that at least the browsing history was around the same period of time as the images were saved, which goes to my argument on the admissibility of the internet search history and browsing history, which was highly probative of the defendant's knowledge that these images contained child pornography. He was continuously searching for these terms, and it belies any suggestion that he didn't know what he was viewing was child pornography, which is an element of the charge. So it is relevant for the Commonwealth to put in that evidence, regardless of what the defendant's theory of defense is. It goes to access to the computer, which did counter the defendant's argument and theory of defense that we know that these images were obtained on this computer, but we don't know who was doing it. Well, we have his search history from various times across a long period of time at odd hours, thus countering any sort of argument that he doesn't know who is making these downloads. It's all under the Victor profile, matching the defendant's name, which is highly probative of his access to the computer and that he is the one doing these downloads. Additionally, it counters it, and I know it's a bit, it wasn't defense counsel's theory at trial, but it was the defendant's statements in the interview with police that these were popping up by accident. The evidence was highly relevant and highly probative to counter that argument. In his interview, it shows that these were not accidental downloads. These weren't accidental pop-ups. This was something he was intentionally seeking out through a long history of searching for this material, and was therefore highly probative to counter that. And in that regard, I think this is much more like the unpublished Creighton opinion, where we're putting in internet excuse me, internet search history to show that this is the person seeking out and this information, and there's no accident. This isn't. It's belying any suggestion that it's popping up.
Counsel, I hear you on all that. Mr. Connolly is not wrong, though, that this kind of overwhelmed the rest of the trial. You have to kind of search to see where the 10 images were put in front of the jury. The rest is all about the search history and so forth. Had defense counsel objected, don't you think there was a good chance a judge would have restricted some of the Commonwealth's evidence on this?
Yes, and I do believe that goes to the substantial risk of the miscarriage of justice. I certainly believe that a limiting instruction would have been appropriate here had it been requested. Of course, there's no requirement that the limiting instruction is given sua sponte, but it likely would have been given. We can admit that directing the jury's attention to the purpose of this evidence would have been important. And I do think, to your point, that it would have likely been restricted on the amount of search history and browsing history that was admitted. But in that respect, I do think some internet browsing history and search history had to go in. It was part of the element. It was highly probative of his knowledge. It was highly probative of his access to the computer. And in that respect, the fact that they would have had to been exposed to some vastly reduces the substantial risk of a miscarriage of justice given the breadth of this material that went in. And it is worth noting, it's a fine point, but it is worth noting that the massive amount of data that was admitted via the CD on the full ADF report, the jury never viewed that. The judge specifically instructed them to return to the courtroom to view the report on a laptop, which they never requested to do. The jury only deliberated for an hour, thereby reducing any sort of risk that they were combing with a fine-tooth comb through this 1,000-page ADF report. What they really were exposed to was the 2 exhibits that are included in the record appendix. Sorry.
Can we turn back to the staleness issue?
Yes.
First, you agree with Mr. Connolly that from the affidavit, we don't know that he necessarily uploaded the image into the reverse search function.
We know that it was a Bing image reverse image search that generated the tip. The trooper states that there are 3 ways in which this sort of tip could be generated. That's by him either specifically utilizing the reverse image search, inputting a URL, or sharing an image. I believe what that goes to is the fact that he's using a Bing search image, and he's either having already searched for child sex abuse material, CSAM, and click share.
But I'm confused as to what the trooper was saying in the affidavit. In general, there are 3 different ways these reports are generated, or in this case? In this case, do we know that he used a Bing reverse image search by inputting that image into...
I see. And I believe what the trooper is saying is that there are 3 ways in which this kind of report would be generated in general. But in that respect, I do not think it matters, because I think any of these 3 methods show a level of sophistication.
Well, what if one of those was, if I understand it, that you do a Bing search and a bunch of stuff comes up and you click on something from that search, on a link from that search, that would generate it?
And the fact that I think goes against that sort of argument is that he also avers that he had to manipulate the safe settings on the Bing reverse image search in order to portray or to show the images of pornography. So if he was making an innocuous search, the images of CSAM would have been obscured by the safe settings of the Bing imagery search. So in order for that situation to occur, he would have had to manipulate the Bing image search engine in order to remove the safe settings that would otherwise blur out images of pornography. That would then portray them. He would then be able to see the images, click on the image, and share the image through Bing. And the point there is that while Guastucci is requiring generally uses the language of sophisticated steps. What it's generally looking for is a willful intention to view the files, and this clearly demonstrates a willful intention, or at least clearly establishes probable cause of a willful intention to view these images, and thus supporting an interested in inference that further supports the inference that he is a collector of these materials. And again, dealing in probable cause, we're dealing with likelihoods, and given as the court has noted, given the three options for how this thing is generated, it's likely that any of these is showing a set of sophisticated steps that are giving that willful intention to view child pornography.
I'm a little confused because, I mean, the probable cause question, isn't it whether there was probable cause to believe that the images or images like it were still on the computer 8 months later?
Yes.
Part of the showing of that is that he was interested in child pornography, which gets you over the typically 8 months is too long problem. What standard, what level of proof does the Commonwealth have to make of the interest in child pornography? You seem to be saying, oh, it's just probable cause that he has an interest in pornography. Is that the standard you think Guastucci establishes?
I am not sure that Guastucci spells out a specific standard for reviewing whether or not the individual is interested in child pornography. I would imagine, given that it arises in the context of a search warrant, that it is a probable cause standard. It's more likely than not that this individual is interested in child pornography. And I think here the facts sufficiently display an interest in by showing those willful steps. And to kind of go back to your original, or your point of like, it's the interested in standard is used to support the collector inference, which is why the images would likely still be on the computer at that time. That was just an original point in the introduction of your question. The actual answer being, I think, yes, it's probable cause that this individual is interested in child pornography. And then And then, as noted, I think it is important to note that Guastucci admits that there is no bright line at 7 months. It is a fact-intensive inquiry as to whether staleness is a fact-intensive inquiry. Here, I think it is clear that where we have shown, where the search warrant has clearly established the interested in, thus supporting the collector inference, the facts here support a finding of probable cause that the items were likely to still be on the computer. There's been an acceptance that this kind of digital evidence is very durable, and the affidavit itself states that stuff is likely to be found even if the user had attempted to delete it. We're starting to see with forensics that you're able to recover these materials long after they have been attempted to be purged from the computer. And so in that regard, I think, given the facts of this case, it was very likely that the very durable digital evidence was still in the location on this computer that was searched. And if there are no further questions, I would rest my
Seeing none, no. Thank you both very much for your arguments. All right, we're going to go ahead and hear the next case without taking a break, and that's case number 2023-0242, GRETA MESZOELY versus HAMID BENBRAHIM. And I know I had a hard time with both names in this case, and so I hope counsel will correct me when you approach the podium. Thank you.
Yes, good morning. May it please the court. I'm Rick Reed. I represent HAMID BENBRAHIM.
BENBRAHIM, thank you.
Who is the defendant in the underlying contempt and is the appellant in this case. Until he was served with a complaint in July 7th of 2022, Mr. BENBRAHIM believed that he was in full compliance with the separation agreement that was filed in early January of 2022. At no time prior to July 7th did he have any indication from any source, whether it was from Ms. MESZOELY herself or her counsel, that he had any possibly deviated from the terms of the agreement. It was only after the receipt of the complaint that he then contacted myself, and within a week and a day, I provided correspondence to counsel for Ms. MESZOELY, indicating that point by point in their complaint for contempt as amended, he had addressed those issues, either at the time of the agreement or before. And the heart of this case is about communication. It's whether or not he communicated information to Ms. MESZOELY that she needed for insurance purposes, for the transfer of property, specifically intellectual property, relating to a business that the parties started during the marriage, which was...
Maybe if I could ask for clarification so that I can focus my thoughts while we're having this argument, and that is that aren't we really just focused on one issue, and that was whether or not there was communication regarding the COBRA coverage?
Yes, the COBRA coverage was the only issue that he was found guilty on.
Right.
And at the time of the agreement, both parties were under the mistaken assumption that his new company, Verimex, which he had, unfortunately, it was circumstances of events where he was starting a new job.
You're not really challenging that particular finding, are you?
No, I'm not challenging the guilt, but
right.
it was not willful.
Just wanted to be sure, so that's,
Yeah.
okay.
I
So
don't
what you're
believe
challenging is, since it was not willful, that's your argument that underscores your claim that there was an abuse of discretion on the attorney's fees.
That is correct, Your Honor, and the damages as well. Because specifically regarding the attorney's fees, there were representations made by counsel that they had to chase Mr. BENBRAHIM for information. That's false. There was never any chasing. There was never any communication at all until the complaint was filed and served on July 7th of 2022, which, by the way, was 2 months after it was initially filed. During those 2-month period, there was no communication with Mr. BENBRAHIM, no communication with me that anything had even been filed. And there was also an allegation that the claim that he brought himself into compliance with the agreement only after being served. That also is false. He believed that the entire time from the agreement until he was being served that he had complied. We presented...
Well, we know his position and what he believed, but I guess what I want to focus on is really what the judge determined and how valid or not valid that is.
Correct.
So it is accurate to say that some of these issues were not resolved until the parties arrived in court in order to address the contempt complaint.
I would characterize it differently, Your Honor. It was addressed, but I read the agreement, which I believe is on page 77 of the appendix.
Mm-hmm.
The agreement can be read as a supplemental amendment to the agreement, providing further points on how performance of, especially the transfer of Fagayu, which is the business that they had started, the application. It was about data transfers. It was about who should receive those data transfers. He had argued that he had done all of that well before, maybe even a year before the actual settlement of the case. All of that information was provided. But for whatever reason, Ms. MESZOELY either didn't receive the information properly, didn't know what to do with the information. She had another tech person that she needed to include in the process of making sure everything was transferred properly. That information was never conveyed to Mr. BENBRAHIM. There was nothing produced by Ms. MESZOELY or her counsel that efforts were made to try to get information from Mr. BENBRAHIM beyond what he had already provided, that he had refused to provide any information, that he was ignoring requests. Nothing like that was produced. So when there's a reference to what did the judge find, we don't know. There were no findings issued here. There was just, you're guilty on the COBRA issue only. I want briefing on that issue only regarding fees and damages. Yet she awarded fees for everything. The total, there were 5 claims or allegations of contempt, only one of which dealt with insurance and the COBRA issue. He was found not guilty on the insurance. He was only found guilty on the COBRA because of a mistake that he believed that there was coverage when there wasn't.
Right.
His company was too small. But there was no basis.
It really comes down to, if I can put it in these terms,
Sure.
that the attorney's fees and costs or excessive in your view, and they should have been limited only to what it would have cost to litigate the complaint contempt with respect to the COBRA issue.
I believe that's the case, Your Honor. I was not able to find any case law specifically dealing with a case brought with multiple claims of contempt, only one of which was actually litigated to completion. The other matters were never brought to the court's attention, whether or not they had merit, and it was never addressed.
Well, is it fair to say they were never brought to the court's attention? It seems to me that in the two hearings, they were all discussed. And the very argument you're making right now was also made to the judge, that there was no chasing, this already happened, et cetera. And although the judge didn't make findings, there was some discussion, well, that this was only resolved now, right?
Well, I'm sorry, Your Honor. There was some discussion about specifically the communications or the lack of communications.
But your point is that without making a finding that regarding when and how those other counts for the for contempt were resolved, that the attorney's fees award was an abuse of discretion.
Yes.
Right? Okay.
Yes.
And to your brother's point that, well, you didn't ask for an evidentiary hearing, so you couldn't necessarily ask for a finding, what is your response to that?
Well, the evidentiary hearing wasn't necessary in this case. I believe everything that we submitted, I think Mr. BENBRAHIM was the only party that submitted any documentation in support of his position. There was no need for testimony by either party. I don't believe there was a dispute, or at least there was no evidence offered in dispute of the evidence that we submitted, stating that he had provided the COBRA insurance from his prior employer a year earlier that was received by her attorney's office. There was no dispute that he had resolved the insurance issue to the best of his ability. There was no dispute that there was a mistake regarding COBRA.
The dispute is when these things were resolved, because you're saying it was all resolved before the complaint issue filed, and no one. And there's nothing I can point to except for your assertions that says that's the case.
And the burden of proof, I believe, is on Ms. MESZOELY to prove otherwise.
However, when both parties made representations
Yes.
to the court and said, I'm saying this, Your Honor, here's my documentation, other parties saying this is the representation, and the judge makes a determination, where are you left with that? Because you didn't ask for an actual evidentiary hearing, so basically she rejected your documentation, so to speak, right? And accepted the allegations that were being made with respect to by the plaintiff as to when these counts in the complaint were actually resolved.
I'm not sure, because there were no findings, I'm not sure what the basis of the award of the attorney's fees was for.
Right.
I don't know if it was because she believed what they were saying about having to chase Mr. BENBRAHIM, that he was refusing, that he was obstructionist. There was no evidence before the court offering that. What I provided to the court suggested the opposite was true, that he believed he was in compliance, that there was a gap of time where there was no communication, there was no chasing, there were no emails, there was no communication at all during that period of time, where someone believes up until July 7th, 2022, they're in full compliance with an agreement dated 6 months prior. There was never even an opportunity for him to address that. But as I said, within a week and a day, I provided point by point for every allegation in the complaint, demonstrating that yes, he was in compliance for these issues. And we thought that the insurance issue was addressed. The damages that were awarded for the insurance, I don't believe was justified either. Because
And you're talking about the $2,573 for the.
Yes.
Okay.
yes, that
So that you object to, but you don't object to the paying the extra in coverage up to December 2024.
only to the extent that I believe that assumes that Ms. MESZOELY was going to choose COBRA over other forms of insurance. The agreement provided that she had an election whether to proceed with COBRA or some other kind of insurance. We don't know what reasoning she would have used to select either COBRA or something else, especially as a cancer survivor. There's other factors that go into the decision of what insurance to take other than just
But by
cost.
saying that you weren't going to present any evidence or question her on this, didn't you accept that as true?
Sorry, and
By waiving an evidentiary hearing and by waiving an opportunity to cross-examine her or even call her as a witness to determine whether or not there was another option she would have taken, haven't you waived that?
I don't believe so, Your Honor. I believe that the again, I fall back upon the burden of proof resting with the plaintiff in this case. If she was going to, and I did ask for information from counsel prior to the hearing, that was refused.
Okay, so to be clear, what you're saying is that this order that you pay, I think it's about extra $200 a month to a certain amount of time.
Yes.
For the difference between COBRA coverage and the insurance that the plaintiff has now, that it was not, there was no evidence to support that.
No, there was, Your Honor. There was evidence to support the difference in the cost. I agreed with counsel as far as her calculation.
But you're saying there was no evidence to support the fact that she would have had that benefit?
Had selected that, had she evaluated both the costs as well as other factors such as coverage, deductibles, and other factors that would go into someone's decision-making regarding that.
And you're saying that in your view, it was then erroneous for the judge to conclude that she had made that, that she met her burden of proof by her own assertions and affidavits, et cetera.
I believe that was an assumption made by the court, Your Honor.
Okay. All right, thank you.
Again, it would just be our position again that the $13,000 award for a single issue of a COBRA coverage that was mistakenly, by both parties, not available to Ms. MESZOELY, I believe is excessive, considering the scope of this case. There were representations that just were not reinforced during the hearing. At any time during the pleadings, there were significant volumes of papers submitted to the judge. There was oral argument presented. At no time was any objective evidence provided to the court to substantiate obstructionist conduct or any other conduct that would justify an award that supersedes the damages in this case.
Counsel, you're correct that the judge found your client liable in contempt for one specific violation. But the wife argues that on a number of other issues, she had to press her case and that your client, if you will, slid in under the tag. Do you disagree with that characterization? And to the extent you don't, isn't that an appropriate circumstance for an award of attorney's fees as well?
It was not, he did not slide in as the clock was expiring to satisfy his obligation. If you look at the agreement, it focuses on just fine-tuning the separation agreement, almost as if it was an amendment to it. How is he going to provide documents that he thought he had been sending her to Nashville? He thought she was in Nashville the whole time, when in fact she was in Boston. There was never any evidence indicating that she had not received anything in Nashville. He had provided her with sealed envelopes that he did not open. He forwarded it all to Nashville as was required under the agreement. Never had he been aware, and as soon as he was aware, as I said, a week and a day later, I provided everything to counsel that he had copies of. I provided links to counsel where she could get information that she didn't have. We did it immediately. Immediately upon learning of this discrepancies, we addressed them. And so again, it goes to page 82 of the appendix, my email to counsel, going through each and every category, showing how he was in compliance with these issues. At that point, that should have been the end of the case, as far as I'm concerned. I tried to resolve the case outside of court. It was not me who pressed the case to go to court. I didn't ask for the hearings. There are multiple hearings. Neither did Mr. BENBRAHIM. That was all scheduled by counsel or by the court herself. We tried to minimize attorney's fees as best we could, but to no avail. It takes two sides to negotiate and discuss things. And unfortunately, it was not returned, our efforts. And as far as the bias issue, if this case does get remanded, my client is convinced that he would not receive a fair hearing before this judge, unfortunately. If the record, looking at the record, counsel for Ms. MESZOELY was afforded ample opportunity to present her case. And if you look at when I present my case, there's constant interruptions. I honestly didn't notice it at the time. I didn't feel like it was I'm sorry, my time is up.
There weren't any motions to recuse, correct?
No, Your Honor, I've never filed one in my entire career, but looking at the judgment and looking back at the hearings and how they were conducted, I believe my client does have a basis to say that, or believe that he will not receive a fair hearing with the court.
But the judge did make one reference to some other stuff, or words to that effect. But didn't the judge also specifically say, I'm not going to consider that? And don't we have to take the judge at...
But the fact that she brought it up on her own,
the
fact she brought it up on her own, unprompted, and without any prompting from either party, that she was aware of a history, that really isn't a history. There was
She was
never any
actually
evidence.
responding to plaintiff's lawyer saying, I'm not going to consider that.
Yes.
So it was prompted. I mean, one can infer that she was making sure that plaintiff's attorney knew, I'm not considering other information.
Yes.
Yeah.
Yes.
Okay.
Thank you, Your Honors.
Further questions? Thank you very much. Okay, counsel?
I guess it's good afternoon. May it please the court, Richard Novich on behalf of GRETA MESZOELY. I'd like to address each of the topics that were just discussed, but before I do, for reasons that are set forth in the brief, the judgment below should be affirmed. The trial court judge did not abuse her discretion, and there are several reasons for that. In his reply brief, Mr. BENBRAHIM identifies a 1984 decision of the Supreme Judicial Court relative to our request to dismiss the appeal based upon a failure to file a notice of appeal after the entry of the order on the post-judgment motion for relief. I will confess that at 4:30 this morning, I couldn't find the language of the 1984 version of Rule 4 of the Rules of Appellate Procedure, but what I did find is that that rule was amended several times since then. I've cited a couple of cases in my brief there's one from, I think it's 2005. It is Anthony versus Anthony, and another one, Beliveau versus Ware, which I suggest are both on point and dispositive. That addresses that issue. But let me go back to the other issues that have been raised moments ago. The agreement that was made prior to the first contempt hearing was made with the assistance of probation, officer of the court. It wasn't any fine-tuning of the divorce agreement. It wasn't a modification agreement. There was no modification pending. The only action that was pending was a complaint for contempt. And if you go through the stipulation that was negotiated, if you will, by probation, and I wasn't counsel at the time, but this is what I infer from the record, what was negotiated by probation at court immediately prior to the hearing, you will see on each of the particular items, I think there are 5 or 6, they track the allegations of the complaint for contempt. They talk about, documents that need to be emailed, the tax liability information. They talk about the intellectual property issues and a variety of other things. It had nothing to do with fine-tuning anything. It was making sure that Mr. BENBRAHIM satisfied his obligations that he hadn't done up to that point.
Right. Well, and you persuaded the judge of the fact that these at least 4 items were not resolved until such time as you filed a complaint for contempt, right?
That's correct.
Okay, but then you only prevailed on the one count, the COBRA count.
I cannot dispute that.
Okay, so how can that be, that couldn't have taken the number of hours necessary that amounts to $13,000?
So I can't speak to the bills. I haven't seen the bills. I don't believe the bills are in the record. But what I can tell you as a practitioner in that court, what doesn't come through in arguments that have been made is all of the other efforts.
I'm going to ask you to stand closer to the microphone if you don't mind. Okay.
Sorry. All of the other efforts that were involved in prosecuting the complaint for contempt, such as phone calls, emails, drafting the complaint. Keep in mind that there wasn't just one hearing in this case. There were multiple hearings in this case. The drafting of the materials, there was a financial statement. You'll see that there was a affidavit, I believe, of counsel or a verified memorandum that was signed by Ms. MESZOELY. Also, that was evidence before the trial court judge that she could have relied upon and in basing her decision. So it wasn't just as simple as we walk in a court and we have a 15-minute argument and $13,000 later, we're going to send you a bill. I would suggest that there was a lot more involved in the proceedings that is not in the record that we see. So let me come back to a couple of the arguments, if I could, that I believe, Your Honor, looks like you're...
Well, I guess your last comment is giving me pause. If this attorney's award was given based on lots of things in the record that we don't see, how are we going to determine if there was an abuse of discretion?
I agree with you, and I don't believe that that is my burden to provide to you. I believe that's the appellant's burden to provide to you.
Okay.
And in the absence of it, I'm not sure how you can. I'm not exactly clear, looking at the brief itself, that there was a clear argument addressing the amount of the fees. The way that I interpreted and understood the brief was no fees should have been awarded at all. And the way that I interpreted the brief, no fees should have been awarded at all for three specific reasons, I suggest none of which have merit. Number one, he suggests that he could not be ordered to pay, as Your Honor identifies, because some of the claims were resolved, not all of the claims were found in our favor. I direct Your Honor's attention to two cases, Wooters versus Wooters, and the 128 decision, I believe, of Justice Milkey, Engelhardt versus Engelhardt, which was in 2021. You may recall in that case, the underlying complaint for contempt was vacated because of a failure of service, but the amount of legal fees that were awarded in the contempt was affirmed. So there's one case on that. The second piece that I would address, as far as why the fees, the total amount of fees were appropriate and not an abuse of discretion, is that Mr. BENBRAHIM would have this court read into Chapter 208, Section 38, language that simply doesn't exist. There is no language in that statute that says a couple of things. He asks and suggests, but the statute doesn't say that he's entitled to prior notice and an opportunity to cure. It does not say that at all. It also doesn't contain any limiting language that deals with, excuse me, I lost my place.
That's okay. I'll ask you a question. It's going to make you lose your pace anyway. Engelhardt is a case, an unpublished decision. Is that what you're saying?
It is, Your Honor.
Okay, and I don't see it in the brief.
I don't believe I cited that. I found that in the last couple of days in prepping for today.
Can you provide us with a citation if you're going to be relying on it, even though it's only for persuasive?
I would be happy to, Your Honor. If I could submit a letter, I'm happy to do that.
You don't have it with you?
I do in my bag, if you give me a
Never mind, we'll find it. Engelhardt, E-N-G-L-E-H-A-R-T.
Yes, Your Honor, and it's October of 2021. It's a Rule 23 decision.
That's enough, thank you.
Now, the record undercuts the argument that has been made that Mr. BENBRAHIM was cooperative. One of the primary thrusts of his claim here is that had my client simply reached out and chased him, none of this would have happened and it all could have been avoided. Let me give you one simple example on why I suggest that doesn't hold water.
Before you do that, can I just ask, is your example going to be something that falls into the category of what the judge said she would not consider and could not consider, or something else?
Not at all, Your Honor. Something else. Now, I'm not going to insult you by regurgitating facts the judge could find, other than these two pieces. The appellant was served with a complaint for contempt on July 7th, 2022. At that point in time, did he say in substance, oh my gosh, you're right, I forgot, I need to fix these things, I violated in a bunch of different ways, let me make it right. That's not what happened here. The first thing that he did was file an answer denying responsibility or denying that he had violated anything. The second thing that he did was he filed a request for fees, in essence claiming that the underlying complaint was frivolous. Thereafter, he waited roughly 2 weeks before even attempting to cure some of the violations. And you'll see in the verified memoranda, I think you'll find it at Record Appendix pages 161 to 165, where you'll see that it was sometime in the middle of July where certain things were remedied. Other things were remedied on August 9th, 2022, the day of the hearing. That stipulation that you can find on page 92 of the record appendix. So it wasn't as if he said, thank you, let me fix it immediately. He fought it. He forced our client to go to court. He forced our client to come forward with additional information. He didn't simply say, I'm going to cooperate, let me get this for you and make it right. Second example I would give you as far as the lack of good faith, if you will. Very simple example. I believe I just heard my brother reference the fact that documents were mailed to my client in Nashville. I believe he said that. I wrote it down. I hope I wrote it down correctly. If you look at he says this in his affidavit that followed the initial hearing, at which the judge said, you can give me some information as to why I should not award fees. This was Mr. BENBRAHIM's affidavit. If you look at that affidavit, and you can find that at Record Appendix pages 141 to 143, paragraphs 4, 5, and 11, Mr. BENBRAHIM says the same thing. I mailed it to her in Nashville. If I had only known that she was in Boston, I would have mailed it there. Sounds plausible. I totally get it. One wrinkle. Take a look at the divorce agreement that you can find on page 27 of the record appendix. Paragraph 1 requires him to email, not mail, email to my client certain documents contemporaneous with his payments of alimony. Now, there's no dispute that he signed the agreement. He signed it freely and voluntarily. He had the advice of his attorney. I don't mean to be pejorative, but I presume that he could read it. Email is not the same thing as mailing. If he truly was going to abide by the letter of the agreement that he signed a mere months before, there was no reason and point for him to mail that to my client in Nashville. None. With that, I will rest on my brief unless there's other questions.
Nothing further. Thank you both very much. Okay, now we've come to our last case of the day. Number 2022-1174, KEDISHA PINNOCK versus HORACE PINNOCK. All right, and Mr. Anderson Garrison, you're the only one arguing before us today.
Good morning, Your Honors. May it please the Court, Stephen Anderson Garrison on behalf of KEDISHA Lee, formerly KEDISHA PINNOCK. This is a case about child support for a low-income family. That's a situation where every single dollar counts, and the difference between one order and another can mean the difference between a custodial parent's ability to provide housing, shelter, and clothing for children. In this case, for 7- and 9-year-old girls at the time of trial. The question for this Court is whether the trial court erred in two ways. First, by finding father's income to be erroneously low before using that figure to calculate child support, and second, by reducing child support even lower after making that determination.
Could I ask a question about, I think, your first point? And if I'm oversimplifying this, please tell me. But where this was a trial by representation, is it your position that if the husband did not adequately establish what the percentages of his auto and cell phone bills were that were attributable to his business, that your client is entitled to have none of those amounts deducted?
Thank you, Your Honor. Yes, the burden is on father to establish the degree to which those expenses can be deducted from his gross personal income. In this specific case, the mother argued that 50% should be used as the figure based on the argument that the expenses were commingled business and personal without drilling down further. But a more detailed analysis to be conducted would have to depend on evidence, and it was father's burden to present that evidence, Your Honor.
Well, except the parties agreed there was not going to be evidence as such.
Point taken, Your Honor, and that's an excellent point. This did proceed by representation, but if you review the transcript, the representations of the father's counsel don't make any statements about the percentage of which.
That is certainly correct, but he did say, my client works as an Uber driver, or the equivalent, 8 hours a day. Under those circumstances, why wouldn't a judge in an informal trial by representation be justified as saying, you know, yeah, he probably makes some personal use, but if you're working as a driver 8 hours a day, it's probably a de minimis or very low percentage.
Thank you, Your Honor. The trial court would have had its discretion to make such an analysis, but in this case, there are no findings, there is no analysis, and the result that the court ultimately reaches isn't that it's de minimis, it's that it's zero. The standard in this...
Well, it's the same thing, isn't it? I mean, what are we talking about between de minimis and zero?
Well, de minimis would require a finding that there's an overwhelming amount of the time he's spent driving, for example, would be for his ride-share services, and only a small amount, 1%, 10%, something like that, I would qualify as de minimis. In this case, there are no such...
Are you sure that's not a reasonable conclusion if someone makes his living driving his car and drives it 8 hours every day?
I'm not sure that it's a reasonable conclusion, Your Honor, because although it's required for the job, it is also a personal benefit. In the same way that an employee might receive in-kind benefits, having a cell phone, having a car provided by their employer, and even if they work 80 hours a week, the law still considers in-kind benefits to be part of an individual's gross income as a prerequisite compensation.
We're not talking about tax law here. The standard is whether it's an ordinary and necessary expense to the production of the income. And if you're an Uber driver, having and maintaining your car, isn't that an ordinary and necessary expense?
It is, but not 100% of it, Your Honor, because the analysis requires a consideration of commingling. And I'll refer the court to the Smith v. Clark case, where the appeals court held that it's proper to disregard or reduce claimed business expenses if they're commingled. And in that case, the trial court found and the appeals court affirmed that the husband was camouflaging his income by reporting it as business expenses when there was a personal benefit derived from that. And I'll also point out, again, that there's no written analysis in the judge's judgment in this case, and that, at least according to persuasive authority, and I'll refer to the Mueller v. Mueller matter, which ironically, again, is another Justice Milkey decision. It's a 128 decision, so it is persuasive, but the appeals court...
We don't know if Judge Milkey wrote it.
I'm not certain of that. I know that, that Justice Milkey, that you were on the panel. But in that case, the appeals court overturned the lower court's decision because there was a lack of the required analysis before the judgment was made allowing these deductions to be taken.
Can I raise another issue that the husband's counsel did say that there were some other expenses beyond the car and the cell phone, specifically food? He said, my client's on the road 8 hours a day, he's got to eat, go to convenience stores, etc. That should be counted. Why couldn't the judge say, think through, well, he makes some personal use of his cell phone, maybe some of that should go, but he's buying all this extra expensive food, it's a wash. I'm going to count his income as 1,000, whatever it was.
The reason that the judge could not do that, Your Honor, is that the parties had stipulated otherwise, and they stipulated that there were certain categories of expenses that could be deducted against father's gross business receipts to determine his gross income. And I'll refer the court to the record.
And did they say, and nothing else counts?
I'll read you the exact language, Your Honor. On Record Appendix Volume 1, page 44, it states that child support shall be calculated pursuant to the child support guidelines using mother's income as stipulated to above and father's income as determined by his year-to-date as of June 17, 2022, business activity, including his gross receipts. The parties leave the applications of any reductions against his gross receipts based on the payments reflected in paragraph 21 to be resolved at hearing. This is under the subheading.
But tell me if I'm wrong. It doesn't say, and no other expenses count.
Your Honor, this is under the subheading conclusion and scope of trial. This paragraph sets forth the issue to be determined by the court. The purpose of the stipulation following the parties' separation agreement was to narrow the issue as far as possible so that the proceeding would require as little evidentiary basis and could be precise. And that was the function of the stipulation, and that was the document that the court accepted and incorporated into its judgment.
And where at the hearing did you tell the judge, Your Honor, his argument about the food and his argument about making a downward deviation are simply beyond the scope of this hearing, and I direct you to the stipulation which makes this clear.
Your Honor, at the time of the trial by representation, I made the statement up front that this was the sole issue for trial and that there were no other issues on the table at that time. Later, there was some discussion of an EpiPen, and the judge herself commented, I don't think this issue is before me, and I stated that indeed several of the things that were being raised weren't the issue that was there to be determined. The judge also indicated that she understood my position, I don't have the exact citation in the transcript, that the issue was about how much of these should be deducted and that I didn't believe they all should be. So I think the record preserves the interpretation of the stipulation. I think the plain language of the stipulation itself and the fact that the court incorporated the stipulation into the judgment suggests that it should be followed and that it was clear.
Could the judge on this record have, in your view, concluded something like, okay, you know, parties haven't given me a lot on how to parse this out, but commonsensically, I'm going to say 80% of the car is business and 70% of the cell phone. Boom.
Absolutely, Your Honor. The court certainly could have. As I argued,
even though there was no refined evidence or even representations in terms of what percentage, what mileage could be attributed to either side of the docket.
Yes. I believe that by proceeding by representation, the representation of the father's counsel could be considered. She says that he drives a lot. I don't think it's unreasonable for the court to interpret that and to consider the fact that he does drive a lot and to draw some conclusion there. But it is required that the court conduct the analysis, and it's uncontested. Excuse me.
I'm sorry. So then, what is the amount that is in contention right here? Because your position was 50% of these expenses is reasonable, right? And so we're talking about really the 50% level up to 100%. Does that make sense to you?
Yes, Your Honor, it does.
Okay.
The amount ranges from at 100% deduction at 197, which is the guidelines order in the judgment, to 293, which would be zero deductions. So there's about a $100 range here, which in real dollars may not seem like...
Well, there's not a $100 range because you don't think it should be zero. You agreed it should be at least 50.
Yes, Your Honor. That was our position at trial.
So we're talking about $50.
Yes, Your Honor.
Okay.
And I'll point out, again, this may not seem like a significant amount.
I'm not making any comment about how significant even $1 is. I just want to know what we're talking about here. What we're really talking about is $50.
Understood, Your Honor. I just want to point out at Record Appendix 2, page 45, we have Mother's financial statement, and you'll see that her weekly food expenses are $140. So the delta here...
You don't have to make any argument about how important $50 a week is to us. The question is whether or not it's reasonable, but the fact that it's important, you can be assured that that's something that we understand.
Thank you, Your Honor. I appreciate that. Continuing on the issue of the reasonableness and necessity of expenses, it's This is not make work. This isn't a trivial task. It's important to determine, and there are two policy reasons that are outlined in the recent Kavanaugh decision. The first is that children should be supported as completely as possible by their parents. Child support should be based on an accurate and realistic amount because what's at stake is crucial. The second is that as a policy in Massachusetts, the law attempts to prohibit creative accounting used to manipulate income, and this is, again, analogous to all sorts of kinds of things, but in family law, we're always looking at the structure of how the income is coming in and what is really reasonable in this case. And in this case, the implied finding that 100%, that absolutely all of it is deductible for business expenses is unreasonable.
Okay, turning, since time is getting short, to your, what you call your second issue, there are actually a number of things you argue. One is that the father or husband actually waived the argument through the stipulation, given that the parties agreed that child support would be determined pursuant to the guidelines. Isn't the problem with that argument that the word guidelines is used in two different senses commonly, to both the specific formulae included in this larger document called guidelines, so when you refer to the guidelines, you don't know if you're referring to the larger document or the...
Yes, Your Honor. It is complicated, but there is a solution to the complication here. First of all, you're very right to point out that it is used in both of these ways. If you look at the child support guidelines themselves, there are many occasions where the expression, the guidelines, stands in for the guidelines calculation, the guidelines amount. You'll see this particularly on pages 24 and 25 of the child support guidelines, mentions of deviate from the guidelines without any additional language to suggest that it's the guidelines amount, or application of the guidelines to mean the same thing. I'll also point out that in the party stipulation, the full sentence is calculated pursuant to the guidelines. The operative verb here is calculated, not determined, not established. It doesn't implicate an exercise of discretion, but the use of the formula in the child support guidelines to get the result. And again, I'll refer to the context of the agreement where this is the final paragraph, the conclusion and scope of trial. It's establishing what's left to be decided, and it's showing.
What do we do if we disagree that this is clear on the waiver issue and consider that statement about calculating it pursuant to the guidelines as ambiguous?
I would suggest that the downward deviation is still an abuse of discretion, even if the stipulation were not binding or if that language were interpreted another way, because the court did not follow the proper procedure for deviating from the guidelines. The guidelines are presumptive, the amount is presumptive, and there are 13 identified grounds on which...
At least one of them deals with ability to pay, which was the primary focus of the husband's argument.
Your Honor, yes, there is factor number 10 or basis number 10 is about a parent's ability to self-support. I would say, my time is almost running out, but that the record doesn't suggest any findings or any consideration of that factor. There's just the amount of ability to pay based on a percentage, which appears to be only fathers.
You can read her statement in different respects, but one interpretation is, I find that the husband cannot afford to pay more than 23%. And now I know that that lies in some tension with the fact that she then ordered him to pay 30% going forward, but putting that aside, to the extent that it is interpreted that way, why isn't that enough of a finding pursuant to factor 10 or whatever you want to call it?
Because the court did not consider both parties' ability to self-support, it only looked at fathers, and it did not make any specific findings of fact supporting the specific basis for deviation as the child support guidelines require. And I'll point out as my last point that father was running a deficit of only $25 a week at the time that mother was running a deficit of $131, with the presumption that, or not the presumption, but baked into that number is father's prior child support order of $242. The self-support of both parties is relevant here. If you look at factor number 10, it says a parent's ability to pay. Some of the factors refer to the payor, but this is about both parents, and the court should have considered not just father's income and a percentage of that, but the needs of the children and the mother.
Okay. Thank you very much.
Thank you very much.
Great. That concludes our hearing for today. The court will stand in recess.